Hi, everybody. So this is going to be the video about Section 30 assessments or parenting assessments. My name's Brian Burke, and I'm a family law lawyer in Toronto. I have to give a disclaimer at the beginning, which is that any bit of information like this that you get is legal information only. It's not advice. It's not advice because we don't have a lawyer-client relationship and because I can't give advice unless I know the specific circumstances of the case and so forth. But I do think it's valuable to have, if you're going through this process, information on various steps of a family law matter. Not everyone will have a Section 30 assessment, that's for sure, but many of you will. And the process can be confusing, and it may be that your own lawyer is not giving you the full details about the process, and hopefully this will fill in some gaps, but it doesn't substitute for getting advice from your family law lawyer. If I'm correct, it's the New York Times Wirecutter, which is their reviews, and they say, in advance of the various reviews, which are usually very good reviews of consumer products, they say why you should trust us. So one of the questions you might want to know is, why should you trust me in giving you this information? The answer to that is twofold. One, don't fully trust me, because again, you really do need to get your own legal advice, and this is just information. But why can I be trusted to give legal information? Well, obviously, it would be based on education and experience. The problem is education alone doesn't give it to you. So what's my experience? Well, I've done many cases with parenting assessments, but more than that, at least 3 data points are valuable and I think relevant. One, I was the president some years ago of the Ontario chapter of the Association of Family and Conciliation Courts, AFCC. You can look up AFCC. It's an important multidisciplinary organization, international, with lawyers, judges, researchers, academics, professors, mental health professionals, court workers, and others whose mission really is to have better outcomes for children and families, the whole family, going through a separation and divorce. I was also on the task force of AFCC Ontario that created the AFCC Ontario Parenting Plan Guide and Template. If you Google that, you'll see that. It is becoming something that's used all over by the courts and lawyers in various ways that I won't get into now. And I was also on the task force of AFCC, but this time the international or broad-based organization, not the Ontario chapter, that drafted what became known as the guidelines for parenting plan evaluations in family court cases or family law cases. And those guidelines are the guidelines that evaluators and assessors, so the American term for assessments is evaluations. So parenting evaluations and parenting assessments are the exact same meaning. Those are the guides that are used mostly by everybody who does this work. So that's some of my background. There's more that is relevant, but I think that might be enough to show you why I may know what I'm talking about in relation to this issue. So what is a Section 30 assessment? Well, I have my phone just to read one statutory provision. It's the only one I'm going to do. It's the only dry part of this, I hope. It's called a Section 30 assessment because the relevant section of the legislation that permits it and under which it's conducted is Section 30 of the Children's Law Reform Act. Section 30 is very simple. Deceptively simple, actually. So let me read it, but I'll explain why it's deceptively simple. Section 30 sub 1, the court before which an application is brought for a parenting order or contact order with respect to a child, so any parenting matter really, by order may, so there's a court order, may appoint a person, and you do have them appointed by a court order, who has technical or professional skill to assess and report to the court on the needs of the child and the ability and willingness of the parties or any of them to satisfy the needs of the child. What could be easier or more simple than that? But it's deceptively simple, as I think I said, because it doesn't really explain what's really going on. So let's explain what's really going on in an assessment. I'll get into various dimensions of it. And I may do another video that describes it in more detail because it is quite involved, but I'll try to go through the key elements right now. So the first thing you need to know about the assessment is, as I said, it's court order, but I want to get into things that you actually want to hear as someone who may be going through a Section 30 assessment. The dimension there that's key is they say someone with specialized skill or technical skill or specialized skills. I forget the exact wording. Doesn't really matter, because what it means is really there's two kinds of, at least in Ontario. In the States it's a little bit different, but in Ontario there's three, but really in practice two classes of professionals who conduct Section 30 assessments. Social workers, usually they're registered social workers, and they usually have an MSW, a Master's of Social Work. Psychologist, usually clinical psychologist, so they have the designation CPsych, and they are registered with the Ontario College of Psychologists, I think it's called. And medical doctors, but rarely now do medical doctors do this work, almost not at all in practice. They could, but so really the two classes of professionals who are doing this work are social workers with an MSW almost invariably, not just a BSW, and usually registered with the college, and psychologists. And probably there's more social workers doing it than there is psychologists. Now, what are they doing with the Section 30? Let's start out with something that actually is hard to figure out because no one's going to really talk about this, but it really gets to the heart of what's going on here. Why would you do a Section 30 assessment? I'm going to talk about the test of it in a minute because there is a legal test. But you'd want it because you want someone other than the parents to report on what's going on with the children on various dimensions. And you want that person to be someone other than the parents for a couple of reasons, one of which is that you want the person who's reporting on the children to be trustworthy. Parents aren't inherently trustworthy when litigating matters on behalf of the best interests of their own child, because they obviously have strong interests in presenting things in a way that quite naturally leads to them being an important person in the parent's life or to child's life, or to minimize issues that may happen, or certainly to suggest that the issues are on account of, if there's problems, the other parent. And in a jurisdiction like we have in Ontario and throughout Canada, or at least in Ontario, I'll say that, where it's the adversary system as opposed to the inquisitorial system, what you have is a circumstance whereby the judges, with very, very limited exceptions, can't come in and say, tell me this, and I'm going to ask questions of everybody. They're not allowed to do that. There's rare circumstances at a conference where they can do that, but that's not the system. The system is the lawyers present the case, which means the parties through the lawyers present the case. So often judges will want someone objective to look at the situation with the children. And of course, if they want that, they don't want just some person off the street. It won't be a lawyer. Lawyers can't be Section 30 assessors unless they also happen to have social work qualifications or medical doctor or psychologist, because the people have to understand child development issues, and they have to understand a whole host of other issues that I'm not going to have time to get into now. So they want someone objective with professional skill, and that's why it's going to be one of those classes of people. Now, should every case have a Section 30 assessment? No. No, they are expensive. They are time-consuming. They take a lot of time, months, sometimes even a year. And to a not insignificant degree, you could say they're intrusive. So not every case should have a Section 30 at all. I'm not going to get into all the names of the cases, but there was in the olden days, it used to be the case that you needed what the courts called a clinical issue to have an assessment, which is someone's got a mental health problem or a child has very specific special needs, something clinical. And then in an important case that was now some time ago, a very good family law judge expanded that and said, that's not really right. We should look at a whole host of factors to see if there should be a Section 30 assessment. And this is not really a webinar to go through legal matters of whether there ought to be an assessment or not. Maybe I'll do that another time. But I'll just tell you now that multifactorial approach where clinical issues are not the only thing that are considered, that's where the law is now, at least the better view of it. Okay, so what is involved in a Section 30 assessment? I might as well jump right into it and go from there. So after the assessor has been retained, and I'll skip over that a bit, the lawyers choose the assessor, and then the assessor, well, I'll just tell you, advises whether they'll take on the matter and so forth. An assessment contract or services agreement from the assessor is delivered to the lawyers, and the parties have to sign it. The assessment contract is a very important document, and it's one that you want to review carefully with your lawyer to go through all the various clauses one by one and understand it all. As I mentioned, assessments are intrusive is the negative way of putting it. Comprehensive and full of information that's gathered is more of a positive way. But the reality is that between that contract and probably some consents, separate consents that the assessor will ask you to sign, if you're one of the parents, there will be a lot of information disclosed in relation to various issues, health information, counseling information. Sorry, I have some bubble coming up here, etc. Police record checks, CAS records, so forth. So it's an important document. Let's then talk about what happens in the assessment. And I'll talk about the overall and overarching rather than the minutia first. In due course, I may do a further session where I talk about some of these individual elements, but I think it's more important now for you to understand holistically what's going to happen. So what the assessor is going to do in the most general way is they have to do an investigation, an assessment, that's why it's called an assessment, of the family in its various dimensions. And in all the various dimensions that they can, or at least a very great degree of them, so that they ultimately prepare a report called an assessment report or a Section 30 assessment report that gets filed with the court. And that report is then a very important piece of the puzzle about what's going to happen in relation to the parenting issues in the case. I paused because I may talk about it at the end or in another segment. What exactly is the evidentiary value of that report, etc. But so they're going to investigate or assess, and then they're going to, from that, write a report. Now, I'm going to tell you at the end that's not exactly always how it turns out, because there's an intermediate step that happens called the disclosure meeting that is sort of customary in at least most parts of Ontario as a preliminary step to the assessor writing the report, but we'll get to that at the end. So what's the assessor going to do? Well, what the assessor is definitely going to do is she or he is going to meet numerous times with the parties, with the parents to the matter. The assessor is also going to see, and this is critical, it's a necessary part of the assessment, watch the parents interact with the child. Sometimes, but not always, the assessor will want to see the parents interact with each other, inter se, between the two of them in a meeting. The assessor is also going to want to speak with what are called collaterals. Collaterals are persons other than the parties to the case, the parents and the child or children. And they can be professional collaterals or personal collaterals. So professional collaterals are people like therapists, the children's doctor, dentists, teachers. Personal collaterals are more, it's often friends who might have seen you parenting, etc. Without getting into all the details, suffice it to say that the assessors are well aware that people put forth as your own personal collateral, if you're a parent, usually are on your side, as it were, or else you wouldn't put them forward. So they're not going to put that much weight, typically, on personal collaterals, what they tell them. The professional collaterals will be very important because they will talk about matters of mental health issues and general health issues and schooling issues and so forth, things that are truly relevant to parenting matters, and not just parenting matters, but to the children's best interests. What will happen is usually there's an intake form that gets filled out. That's an important one to actually go through with your lawyer and not do it without showing your lawyer. And in fact, throughout the assessment, you should be consulting with your lawyer and making sure that you understand the process or what is likely to be the process and so forth. It's not to coach you to be different than you are. That would be wrong. But it's not also nice if you're going through an assessment to be surprised. So you want someone with experience in assessment so they can tell you, look, in a usual assessment, this is what happens. It's going to be like this and this and this and so forth. So the assessor is going to here take a detailed family history, usually a family of origin history of each parent, because they want to understand that, and also marital history and what led to the separation. They'll want to know if there's been any family violence. They'll want to know history about parenting, history about work. They'll want to know all those dimensions, and they'll get that principally from meetings with the parents. For the meeting with the child, there usually is, in fact, invariably more than one. It would be considered improper for there just to be one meeting with the child and a parent. Very often it's actually 2 meetings per parent, but at a minimum, what you'll want is, and what they try to do is have, if say that meetings with the dad and the child and the assessor's watching, if the assessor doesn't come to the home, then the assessor is going to want the dad to take the child to the meeting, and similarly if it's the mom. And sometimes the assessor will also speak alone with the child. And one dimension that's important in assessments, there's a bunch of statutory aspects beyond what is set out in that section of Section 30, part of Section 30 that I read. There's family law sections of statutes that they should consider, and they consider far more than that. But one of them is the views and preferences of the child to the extent they can be ascertained. So they're going to want to speak to the child, and they're not usually so brutal as to ask a question like, who do you want to live with, mom or dad? That would be considered quite inappropriate. But they may ask questions such as, how do you experience the time with your dad? What are some of your favorite things to do with your mom? And so forth. And by asking questions like that, and there's a way of questioning children. This is partly, there's a way to do it and a way not to do it. And this is partly why you actually need someone with specialized expertise to do an assessment, because interviewing children is actually quite complicated. You want to make sure you're not using cross-examination style where you're suggesting the answer to the child and getting them to agree with you, like you often see in a cross-examination. Like, isn't it the case that X? That's totally inappropriate with the child. You're not going to get the right data. So that's partly why there needs to be someone who understands how to interview children. In another segment I may do, I'll talk about the voice of the child and a voice of the child report, which is a different thing, related but different to assessments, but quite different actually. In any event, apart from all that, and they'll gather the information from the collaterals, they may also, they're going to look at the Children's Aid Society records. So if there's any CAS involvement, they're going to have to do that, and they're going to look at police records. They may also do psychological testing. And very often, well, certainly if it's a social worker, the social worker won't do the psychological testing, her or himself, because they're not qualified to do so. They'll get a psychologist who understands psychometrics, and they will employ usually several of the standardized and validated psychometric tests like the MMPI-2 and personality assessment inventory, that kind of thing, to help understand more about whether there's any psychological dysfunction, etc., that may be present. The reality is the courts and the assessors, when the assessor looks at the good assessors at least, when they look at psychological testing and psychological assessments, it's not the case, for example, that they'll say, oh, this person has narcissistic tendencies that have shown up, so therefore they're not going to be a good parent, and I'm going to say they're not going to be, and a judge is going to say, oh, we can't have someone who has narcissistic personality characteristics parenting. That's not the way it works. It really is, one way of thinking about it is the psychological assessment amplifies the rest of the assessor's work, or should be seen that way. And when it's dissonant and discordant from what the assessor finds, that's actually probably, for the good assessors, more of a basis to say, I got to look deeper at this because something's not meshing here. So those are some of the dimensions. And frankly, what they do with all this, I'll call it a database. They also ask for very often the court record so far. So the pleadings in the matter, and I'll talk about court documents and so forth in another segment, but right now I'll just say the pleadings and any motion materials, sometimes financial statements, but you might say it's not relevant, but sometimes they want them. Parenting affidavits, the 35.1 affidavits in Ontario, and so forth. And that will give them a sense of who's asking for what in the litigation, etc. At some point in the assessment, the assessor will often talk to the parents and say, look, your spouse says this. What's your comment on that? And they want to hear the views about the other parent and so forth. Want to hear your reaction as the other parent to the views of the other parent and their concerns. And it's important to talk to your lawyer about that, of course, because you want to be seen to be you want to tell the truth. You have to tell the truth. You really do. But you want to, be seen to be engaged with it, not just bad-mouthing the other parent. In fact, you shouldn't bad-mouth the other parent. And they'll also want to know, they'll want to know at some point, what is your plan? What's your parenting plan? And, as I mentioned before, I was on the committee, the task force that drafted the AFCC Ontario Parenting Plan Guide and Template, so you can find out a lot about parenting plans by reading that document. But that's sort of the critical thing. What will be the plan for decision making and for parenting time, most critically those two things, with children, and all the details that go with it, including dispute resolution, travel, you name it, communications, and so forth. So we can talk about parenting plans in another segment, but they're going to want to know what your parenting plan is as part of the assessment. And that's one that you definitely want to speak with your lawyer about, because those are elements that you don't want to try to figure out on your own. You should be quite deliberative and careful and thoughtful about your parenting plan, and your lawyer should be able to help you about it along with the additional resources that I've mentioned.